But they're gonna work.
I'll close it. Be careful to the jet engines.
Richard and I have been getting along somewhat like that. We've got proof of our. I'm suspicious.
We let you get reached on the church. We did about non-pay.
All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present or here. Raise your hand so I can mark you down as present. John McLeod, waiver of arraignment filed, approved, pretrial set January 10th. Mr. McVeigh is going to be appearing via Zoom. We'll recall his case. Anthony Murray. Anthony Brown. Mr. Brown, your attorney is ill this morning. He's not going to be here. I'll call you up just a moment, okay? Jesse Epperson. Same for you, Mr. Epperson. Isaiah Smith.
My counseling on it.
Morning. Good morning, Mr. Sorry.
Good morning.
Charles Bennett.
Here.
James Bustamante.
Here.
Joseph Cronin.
Here.
David Dixon.
Here.
Jeremy Estridge.
I spoke to this guy this morning, he's sick, I think he contacted Penny. I told him right outside.
She said.
Either way, I'll track him down.
Okay.
He's sick.
Bobby Evans. Bobby Evans. Bobby Lynn Evans.
Bobby Evans?
Kenneth Henderson.
You're up.
Jeremy Hester. Nathan Capfield.
There.
Christopher Nash.
Here.
Jennifer Rawlings. Brandon Sanchez.
Here.
Dugan Toms. Michael Tuff.
Here.
Katie Williams.
Here.
Kenesha Williams.
Here.
Javier Zarate.
Here.
John Piercefield.
Here.
Joseph Rushing.
Here.
Debbie Spriggs.
Present.
William Hayes.
The council's John.
Thanks, sir. All right, that's who I have on the docket. Is there anyone who's in here? Your name has not been called. Right, so Mr. Elliott's clients, Mr. Brown and Mr. Epperson, if both of you gentlemen will come forward. Mr. Woodwide, do you have any information on Ms. Heisel, any slide just to your right, right there, that's good, sorry, yeah. Do you have any information on Mr. Elliott, the status of these cases? He indicated to the court that he had 2 agreed passes, but we showed that one of these, Mr. Brown, was going to be set for plea today.
Yes, Your Honor, I can now on Mr. Brown's case. Mr. Elliott and I do have the agreement in place. However, Mr. Brown lives out of state and it's gonna require interstate transfers. We were gonna try to get with probation today and get that information already in the works versus we're trying very hard to give them a heads up on those. And so that's why we were requesting the reset to January to get all of those things in place for that transfer.
Okay,
And
What-
Judge, on Mr. Epperson, I believe we have at least the framework of an agreement. We're working out on restitution, financial information regarding these cases. We were gonna reset it so we can work on that, make sure we have everything squared away.
okay. So what I'm gonna do, gentlemen, is I'm gonna reset both of your cases for January 24th. Okay, Mr. Everson will be set for docket call January 24th. And Mr. Brown will be set for plea on January 24th. I'm gonna have you gentlemen sign this notice of appearance. Right there, where it says the fifth, Brown, under that bold type there. We have any counsel that's ready? Mr. Sir? Isaiah Smith? All right, Mr. Smith is set for pretrial today, Mr. Massar. You believe you have all the discovery from the state?
I do, Your Honor.
Any-
That's put on the docket call. I've been working with the state.
So no contested motions?
No, Your Honor.
All right, court finds no contested motions. We'll set this matter for docket call. You have your calendar with you, Mr.
Yes,
Starr? I've got Thursday, January 5th. Tuesday, January 10th. One of those better than the other.
Well, I'm gonna be in trial on the 9th for sure in Rockwall.
You want Thursday the 5th?
I'm gonna be in Collin County. I heard you say that 24th. I've got the 24th completely open.
Okay, all right, court will set Mr. Smith in for docket call on January 24th. And what I'll be looking for that day is an announcement from the state defense as to whether we're gonna be trying the case or pleading the case or resolving it in some other manner.
Yes, Your Honor.
All right, Mr. Smith, once you sign and get the yellow copy, you're free to go.
Thank you, Judge. Great to see you.
Yes, good to see you, sir. You know. All right, Mr. Wyatt, are you ready?
Yes, sir.
All right, William Hayes. This is cause numbers CR 22, 300, 301, 302, 303, 304, 305, 306. I'm sure that we're set for pre-trial today in all these cases. Go ahead, Mr. Wyatt.
Yes, I've spoken with Ms. Curry and we have all the discovery that she had. She assured me of that. We have no contested motions today.
Set for docket call.
Yes, sir.
All right,
And Your Honor, if we could,
go ahead.
could we have the 24th also? We've got some information that we need to get regarding the family law matter in Dallas County right now. And Ms. Curry wanted to get some of that information. We're getting that together, putting it all together right now.
Okay. All right, the court will set Mr. Hayes in for docket call on January 24th. That will be at 9 a.m. And let's see, on the 24th, I'm not sure what courtroom we'll be in.
Yes, sir.
Chance we could be back in my courtroom or a chance that we could be anywhere else, but we'll keep you advised. I'll let you know.
Thank you.
All right. All right, Mr. Let's see, and I do need Mr. Hayes' assistance. So Mr. Hayes was arrested on these charges, or some of these charges at least, outside of Van Zandt County And so we need to procure his fingerprints for CJIS reporting. So what I have here are, I don't know what this Abraham is. These appear to be originals, but maybe she's already scanned. I'm not sure. I'm just gonna give it to you. So I'm gonna give your client these TRN processing orders. You'll just take these and go out to the Van Zandt County Justice Center, show them this order when you walk in. They're just gonna take you back there and get your fingerprints. You know, you're not gonna have to change out or stay in the holding cell or anything like that. Just go in there, get your fingerprint so we can report that to the state, and then they'll let you go. And they'll try to expedite this as fast as they can. They may be a little short staffed, so be patient with them. But I need you to do this for the court, okay?
Thank you.
Thanks, sir. You have a parent slip. Have you filled one of those out yet? Right there to your right. And you'll leave the white one here and your client will get the yellow one.
Yeah, sure. Okay, I'll run all of those out right back.
Mr. Stevens,
John Piercefield, Your Honor.
Mr. Piercefield. This is CR 2275. Have him set for pretrial.
It's a arraignment, I believe, Your Honor. This is my first court sitting on the case. So I was assuming it was.
Judge, this was one of Mrs. Chester's cases, and I believe that when she joined the state, she withdrew, Mr. Stevens was appointed. I believe Mr. Piercefield has been arraigned on this. But this, I do believe, is Mr. Stevens' first appearance.
That is correct.
So has the state given discovery to Mr. Stevens? Mr. Stevens, have you requested discovery?
I have not requested. I got portal issues, so I don't know if it's there at all.
What are the portal issues?
Me. Changed my password and got locked out, so I got a call.
Judge, I do show, let me make sure it's been sent. Yes, I do show that we've uploaded discovery to the portal for Mr. Stevens, so it should be available for him. I've also provided the state offer to stay in court on it.
What about any physical discovery that needs to be picked up?
I will tell you that Ms. Milton typically does that, but let me double check our notes and see. She usually does, but.
Yeah.
Which I don't show notes that it has been copied from Mr. Stevens, so I'll make a note for Ms. Melton today to get that done.
Okay, all right, court's gonna set Mr. Piercefield then for pretrial. Again, see, because Mr. Piercefield's been here since April. He was set for arraignment in April with Ms. Chester, so he's had an arraignment pretrial. 1, 2, 3, 4, 5 docket calls. Today's pretrial, so I'm gonna issue one more pretrial, but we're gonna have to get, we need to get Mr. Piercefield moving. All right, Mr. Stevens, I've got January 5th, 10th. Either one of those. 10th.
Yes, sir.
All right, court sets Mr. Piercefield in for pretrial on January 10th. That'll be at 9 AM, and we will be, I believe, in the county court across the hall. And Mr. Petersville, I show that you're still delinquent on your pre-trial release money. Are you making a payment
I
today?
can make a payment today.
How much can you pay today?
Yeah.
Okay, and you know you're delinquent 350.
Yes.
So how quickly can you get that resolved?
I just started a new job, so probably next week.
Okay, I want you to pay that 100 today and report to Mr. Waddell, and they'll work out a plan on getting you caught up.
Okay.
Yes. Thank you, Judge. You're right. Dwight, are you ready?
Okay. Joseph direction.
Joseph Craig Rushing, CR 22156. All right, Mr. Rushing is set for docket call.
Your Honor, I believe you've got a motion in front of from the state.
Judge State left the motion to dismiss on the bench. Well, when I left it, it was nothing up there.
All right, Mr. Rushing, the state has tendered a motion to dismiss in your case. Court will grant the state's motion, and you are free to go.
Your Honor, that's all I have today, but at the break, I will need to speak with you about a matter concerning tomorrow's tax docket to make sure
Okay.
whether I can or I can't go.
Okay.
Tax docket tomorrow.
Put that on gallery. Let's bring in Mr. McVeigh on Zoom. Carl Buck McVeigh, CR 22223. Yes, perfect. All right, Mr. McVeigh, good morning. If you'll unmute your device there.
Can you hear me?
Can you see and hear me okay?
Yes, sir.
All right, give me just one moment. I'm not hearing you at all. Can you say something for me, Mr. McVeigh?
Yes, sir. Can you hear me now? Let's see if I can. It's like,
Stand by just a moment, Mr. McVeigh.
yes, sir.
Set the switch rate is an issue.
Which switch was that? The speakers? It's showing power. Mr. McVeigh, say your name again.
Carl McVeigh.
Yeah, I'm getting nothing. All right, Mr. McVeigh, hang on just one moment. Be with you.
Yes, sir.
Sheriff's Office is telling me that they can hear on YouTube, they can hear Mr. McVeigh on YouTube. I think it's just speakers.
All right, Mr. McVeigh, let's try again. Say your name for me.
Carl McVeigh.
Now I've got you. All right, Mr. McVeigh, sorry about that. This is cause number CR 22-223, State versus Carl Buck McVeigh. Mr. McVeigh, I understand you're having some medical issues, is that correct?
Yes, sir.
All right, and so I guess we have some documentation here that says you just had some surgery within the last week or two, is that correct?
Yeah, on the 14th. And I stayed in the hospital for a week. So they took out a tenth of my kidney with a tumor and one of my lymph nodes.
All right, so that's fine, that's fine. So Mr. McVeigh, what I'm gonna do is I'm gonna reset your case today. Do you have any update on your ability to hire an attorney?
No, sir. It took every bit of the money all my family and everybody had to get the copay to get the surgery. So, but we're working on it.
If I reset you until January 24th, do you think that your family or you would be able to pull together the resources to hire you an attorney to represent you in this matter?
I'll do the very best I can. Yes, sir.
All right, the court's going to reset Mr. McVeigh until January 24th at 9 a.m. Mr. McVeigh, since you're not here, you're not going to get an in-court notice. So I'm giving you this oral notice at this point, okay?
Yes, sir. I'll put it on my calendar.
January 24th at 9 a.m. and the 24th appears to be, it's going to be a Tuesday, okay? Just
Yes, sir. Thank you for working with me.
You're welcome. Just report here to the courthouse.
Yes, sir. I'll do it. Thank
All
you.
right, thank you, Mr. McVeigh. Have a good day.
You too.
All right, we'll put that back in the gallery. Don't have to sit there and watch myself. Ms. Spriggs, CR 21-372. Ms. Spriggs, your attorney, Mr. Wood, has filed a motion for continuance. The court has granted that, so I'm having you appear today to make sure that you check in with Mr. Waddell with pretrial release. Have you been checking in with Mr. Waddell? You've never had to? Well, we need to make sure that you do, because you should have conditions of pretrial release. Okay, well, we're gonna get that done today then. State, do you have any kind of information on your dealings with Mr. Wood as to a reset?
I spoke with Mr. Wood yesterday. I believe he wanted it if possible. Obviously, we are carrying this for the Ms. Briggs' sake of the defendants. His case is obviously much more important. So I believe we talked about early February would be good, and hopefully we can reach some sort of I don't think we're going to reach a resolution as to Mr. Casey Spriggs' case, but hopefully we reach one as to Debbie Spriggs in that time period.
All right, Ms. Briggs, the court is going to set you for Tuesday, February 7th. I'm going to set you for a docket call on that day. So what I want you to do is I'm going to have a notice of appearance. You're going to sign that. We're going to give you a yellow copy with your date on there. And then I want you to meet with Ms. Abraham, Mr. Waddell. So Ms. Briggs, the court has conditions of pretrial release. Let's see, I signed conditions of pretrial release on November 9th. And so what conditions of pretrial release also known as or conditions of bond. When you were arrested, you posted a bond, correct? So there's gonna be conditions tied to that bond. You're gonna have to report, drug test, no violations of the law. If you violate any of those conditions, the court will find your bond insufficient, put you back in jail, okay? So Mr. Waddell and Ms. Takerhand, they're gonna be getting that paperwork together. If you'll just go ahead and have a seat in the hallway, they'll be with you shortly, okay?
Thank you.
Thank you, ma'am. You're welcome. Mr. Schmidt, are you ready, sir? Who are you ready on?
Starting with, court down Mr. Hester here this morning, we had a medical emergency with the child gates and children. And signed him at least next week.
Jeremy Hester.
Yes, sir.
All right, CR 21-291, State versus Jeremy Wayne Hester. He was set for docket call. Is there any announcement on docket call?
Judge, I think we were supposed to resolve there and ask him to call Mr. Hester. He had got caught up with his newborn, basically the newborn has been sick, so she's been going through that all this getting together. And she's got worse today, so hopefully we can get her resolved and we get this case resolved.
All right, court will reset Mr. Hester.
I'm asking for that February 7th. On most of my clients, if that's all right. I'll be out a good portion of first of January.
What about the end of January, January 24th? I see that you're gonna be out beginning of January, January 10th, but what about the January 24th?
I'll be back in town. The reason why I'm asking for that February date is because I'm sure I'll be catching up on all the stuff that's piled up on this one.
All right, court will set Mr. Hester then for docket call on February 7th. If you'll let Mr. Hester know he's delinquent about $250 on.
He told me it was one judge, I can't remember, he didn't make a payment. We left with it. Also asked him to send an update from the hospital billing. That's what he's at.
Thank you, sir.
Also, Jeremy Hester, support called him, he's in the hallway with the mask on, told him to stay out of the way. The court wants him to bring him in, he's right there.
What is he claiming?
He's claiming sick. I don't know the specifics. I don't know his diagnosis. He looks like crud. I think he's been throwing up. But we can bring him in, make him announce it.
No, that's okay. CR 11-119, State versus Jeremy Wayne Estridge. Motion to revoke. Go ahead.
Judge, motion to adjudicate Mr. Hester to the initial plea. There was a substantial amount of restitution that he was required to do. I looked at his balances, as of today, he's paid close to $50,000 in restitution. It's almost much. The lead piece expired. I talked to Ms. Curry yesterday. The main issue with him is the remainder of that restitution. He's got a couple other violations, but he's still in a lot. She's agreed to reset him to get hopefully caught up or paid up on his restitution. We seem to believe that he can do that in short order.
Is that the only concern in the motion to vote is the restitution?
That's not the only violation. Was it? I can't recall the others, but it seems to me they were technically, there might have been, and of course, the state has access to that right now. It could have been a reporting issue at some point, but he's been on since forever. It's a 2009 case, so I think all the allegations are encompassed.
Probation department have any concerns regarding controlled substance or anything that we need to test today in light of this less significant?
Judge, there are no alleged narcotics violations. His alleged violations are billed to appear in April, May, June, and July of this year. Failed to pay supervision June and July of this year, and is behind on the restitution, as Mr. Schmidt would like to report. Those are the only alleged violations that we have at this time.
All right, court will set Mr. Estridge for February 23rd on the evidentiary docket for a status and update. No, I'm sorry, let's don't do that evidentiary day. Let's do, are you available on the 21st, February 21st?
Yes.
All right, we'll put him on for an update on his restitution and any announcement on the resolution. If you'll go ahead and have him sign and get him out of here, we'll move on.
Andrew?
Here's another one thing you said. Here. Rachel, you close that. So, last bit. Yeah. All right, who you ready, Mr. Smith?
Anthony Murray?
Anthony Murray? All right, this is cause number CR 22-336. Mr. Murray is set for arraignment on the charge of manufactured delivery of controlled substance, penalty group 1, greater than or equal to 400 grams. Mr. Murray has requested court appointed counsel. The court has found him to be indigent, has appointed the Honorable Richard Schmidt.
Judge, actually, I'm retained on Mr.
Oh, you are? I'm sorry.
Yes, that's okay.
All right, court will have the record reflect that Mr. Schmidt is retained counsel and that Mr. Murray has not requested court appointed counsel. And we are set for arraignment, correct?
That's correct, Judge.
Are you ready?
I am, Judge, we reviewed the charges against Mr. Murray. His name is spelled correctly, based formal reading. There's a plea not guilty, asked for a pretrial date.
All right, court will find that Mr. Murray has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. The court will set Mr. Murray for pretrial hearing on February 7th at 9 a.m.
The judge checked with Mr. Whitehouse, he has signed his conditions and has been meeting with them, so we're good to go.
Great, thank you, Mr. Schmidt. Thank you, Mr. Murray, you're free to go. You ready?
Rollins?
Jennifer Danielle Rollins, CR 22-226. Ms. Rollins is set for pretrial.
That's correct, Judge. We don't have any contested pretrial. We received no in state, which Ms. Rollins intends to be set. We would ask them to be sent for the
All right, court will set Ms. Rollins for plea on February 7th. That will be at 9 a.m. If things go as planned, we'll be back in our courtroom upstairs.
So where will we actually be about that? I said, where will we actually be?
Don't know. Don't know. And Mr. Schmidt, I'm gonna have Ms. Rollins give your analysis test today. A pretrial request.
Yes, sir.
All right, So if y'all just have a seat in the hallway, and Mr. Waddell or Officer Mature here will be with you shortly. Next one, Mr. Schmidt.
Katie Williams.
Katie Williams, CR 22-299. Ms. Williams is set for pretrial.
That's correct, Judge. No contested pretrial as per docket.
All right, court will set Ms. Williams in for docket call on February 7th at 9 a.m. All right, Ms. Williams is free to go. Charles Bennett. CR 22-125, CR 22-238.
Judge, we're set on docket call. We received an offer from the state.
Is Mr. Bennett here?
Yeah, he was right there. He was right behind me. Then. Yeah.
All right, go ahead, Mr. Schmidt.
We'd ask for that it's not quickly.
All right, court will set Mr. Bennett for plea on February 7th. And that will be at 9 a.m. Mr. Schmidt, there's been a request to have Mr. Bennett submit to a UA for his failure to appear in delinquency. So just go ahead and go with Mr. Waddell, Mr. Bennett, and then we'll return to court for an announcement. Michael Cole Tuff, CR 22-296. Mr. Tuff is set for pretrial.
Correct, Judge. No contested pretrial as per docket.
All right, court will set Mr. Tuff then for docket call on February 7th at 9 a.m. And Mr. Schmidt, while he's signing that, I'll show Mr. Tuff to be delinquent on his pretrial release. Do you have any information about payments?
He's got money in there.
How much do you have today? Okay, thank you, Mr. Tuff. That's what you're delinquent, so. Kenesha Williams, CR 22-199. Ms. Williams is set for pretrial.
That's correct, Judge. I think this is our second pretrial setting. Now we requested an additional last time. We're gonna request an additional this time. For no other reason than we have to do discovery matter. We've got some issues. She lives. So we're trying to coordinate. I know it's a delay, but if the court was indulged with one more pretrial.
Any objection from the state?
No.
All right, there being no objection, the court will set Ms. Williams for pretrial on February 7th at 9 a.m. You're welcome. Anderson. Kenneth Jerome Henderson, CR 22-325. Mr. Henderson set the pretrial.
Right, Judge, at this point, we have no contested pretrial. I would ask the court to leave to file a late pretrial motion if it becomes necessary. I don't think it will, but it's one of those cases where it's a little bit tricky. But at this point, we're asking for that.
Is there anything that you think would cause a late pretrial filing as far as discovery or?
We don't have any discovery issues. It would be a review issue on my part.
Okay. All right, court will set Mr. Henderson for docket call on February 7th. I'll be at 9 a.m.
And I have reviewed the discovery pretty court, so I feel like I need some in-depth. More
Yeah.
in-depth.
Court would entertain a motion for late filing if it becomes necessary.
Nathan Cab.
Nathan Caphill, CR 22-220, 221, 231. Set for docket call.
Is correct, Judge. I'd ask for one final docket call, Mr. Capital. I think that me and Mr. Woodwhite started to discuss some of the issues on the videos. He and I need to do this together. Pertaining to evidence. If the court allows that one more docket call, Mr. Capital.
State of objection, Your Honor. We are in negotiations. Mr. Schmidt has brought up some issues that we need to further discuss and likely watch the video together to decide whether those are valid or not.
All right, the court will set Mr. Caphill for docket call on February 7th at 9 a.m. Mr. Caphill, I'll show you're also delinquent on your pretrial payments, about $200.
Yes, sir. I was gonna pay 40 today. I've been trying to have. I live in Northeast Texas. Weather has been real good up there. So I've been struggling here lately. I'm gonna pay 40 today and I can have it caught up.
Okay. Court will set Mr. Caphill for pretrial status on that day as well.
Status on pretrial, not pretrial slash separation.
Pretrial release status.
I was like, why are we going back to pretrial? I understand what you're saying.
Christopher Ryan Nash, CR 21-388. Mr. Nash, set for docket call.
That's right, Judge. I think previously, Nash had an attorney announced ready, asked the court to put Mr. Nash back on docket call so they do negotiate this thing. At this point in time, state's being offered Mr. Nash.
You had Casey Chester before, is that right? That's what I thought. Okay. And you said docket call, Mr. Schmidt? Jury selection. Okay. All right. So Mr. Nash has conducted all of his plea negotiations with the state. State's made their best offer, made their best counter offer. There's no resolution.
As far as I know, there's no resolution. The state's made a defense on for Mr. Nash.
And what is that offer? So I can have that on record.
6 TDC.
6 TDC. All right. And Mr. Nash is rejecting that today.
Yes, sir.
Okay. All right. The court will place Mr. Nash on the jury selection docket. We will begin that. January 30th. I believe. Yeah, we'll start that January 30th. And so, Mr. Nash, you've been on jury selection before. You know how that works.
Yes.
Okay. Your next, Mr. Schmidt.
Javier Zarate.
Javier Zarate. CR 21-399. Mr. Zarate is set for docket call.
Correct, Judge. We're gonna ask him to make a docket call, continue negotiations.
Any objection from the state? All right, court will set Mr. Zarate for February 7th at 9 a.m. Mr. Schmidt, there is a request to have Mr. Zarate submit to a UA. So I'm going to order you to submit to a UA today. So that means you're not free to leave until I get the report of that. Okay. All right, just have a seat in one of those chairs right there, and then Mr. Waddell with the pre-trial release department will be in with you shortly. Okay. You'll let Carl know that we have him waiting. Mr. Schmidt.
Jacob Dixon.
David Paul Dixon, CR 22-269. All right, Mr. Dixon is set for on burglary of a building for docket call.
Correct, Judge. The state filed a misdemeanor information in the county court of law on Mr. Dixon. We arraigned him last week. I'm going to file a motion to transfer that to Cary with the state jail. And ask for an additional docket call in this case. Let's get that case.
Okay. All right, court will reset Mr. Dixon's case for February 7th. The docket call. And Mr. Schmidt, I show that Mr. Dixon is delinquent $120 on his pretrial release.
Says he can get $100.
And we're gonna UA Mr. Dixon today as well. So Mr. Dixon, just have a seat right over there. We'll be with you shortly. Your next one, Mr. Schmidt.
Joseph Young.
Joseph Cronin. CR 22-322. All right, Mr. Cronin is set for pretrial.
Correct, Judge. At this point, we don't have any contested pretrial notice on file.
All right, court will set docket call for February 7th at 9 a.m. I show that there are some issues on pretrial release that Mr. Cronin didn't report in October. He's delinquent almost $200, and the court's going to UA Mr. Cronin today. So just have a seat over here, or have a seat in the front there.
Remainder of my comments are please, Raj.
Yes, sir.
Yes, sir.
Fantastic.
All right, court is back on the record in state of Texas versus David Paul Dixon. Mr. Dixon, step up. This is CR 22-269. The state has set Mr. Dixon for docket call on February 7th. Court has administered a urinalysis test to Mr. Dixon today. Mr. Waddell, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, go again. And Mr. Waddell, the court instructed you to administer a urinalysis test to Mr. Dixon to test for the potential presence of controlled substances. Did you conduct that test?
Yes, sir.
And what were the results of that test?
Positive for marijuana and methamphetamine.
Okay, and did you share that result with Mr. Dixon?
Yes, sir.
And have you had a chance to share that with Mr. Schmidt? Have you had a chance to share that with Mr. Schmidt?
No, sir.
Any questions, Mr. Schmidt? Okay. State any questions, Mr. Warner?
No, okay.
Okay. And did Mr. Dixon admit or deny?
Yes, he signed an admission statement.
Mr. Dixon, you're aware that you have conditions of pretrial release in this court. You understand that you're in violation of those conditions today.
Yes.
As a result of your admission, your testing for controlled substances and your admission, court is going to find that you have violated the conditions of your pretrial release. The court is going to find your bail to be insufficient at this time. So I'm going to order the bailiff to take you into custody. It's best for you to talk to Mr. Schmidt, your attorney. Mrs. Zarate. All right, back on the record, CR 21-399, State versus Javier Zarate Jr. Court has requested a urinalysis test to be performed on Mr. Zarate. Mr. Waddell, I've already placed you under oath. You understand that your testimony is still under oath for purposes of this matter.
Yes, sir.
Did you conduct a urinalysis test as requested by the court on Mr. Zarate?
Yes, sir.
And what were the results of that test?
The test results was positive for marijuana.
Okay. Did you share those results with Mr. Zarate?
Yes, sir.
Did he admit or deny the result?
Subjectively, the date he would give me was October 31st. Personally, I think there's a sooner date. My understanding doesn't stay in that in your system that long. But that's results that he was given today.
Was Mr. Zarate on conditions of pretrial release in October?
Yes, sir.
Did you share those results with Mr. Schmidt?
No, sir.
Mr. Schmidt, any questions, of Mr. Waddell?
Yeah, I was unclear whether or not Mr. Zarate, did he sign an admission on the UA?
I apologize for not getting to you.
Oh, that's okay. I mean, I was unclear about your answer, whether he admitted
He admitted, he signed the admission.
and basically he admitted
That was.
that was in October.
Yes,
And are you certain as to whether or not that amount could linger to this point if he was regular use prior to that?
I would doubt it,
And you would be mean to Mr. Warren.
but I'm not.
Are you certain or not certain?
If it's possible.
Any questions for the state?
And just to clarify, Mr. Waddell, he was in fact on pretrial conditions of pretrial release. The dates that he admitted to using those items.
Yes. No question.
Anything further, Mr. Schmidt?
I agree with Mr. Zarate.
All right, Mr. Zarate, for the purposes of this hearing, just raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, okay, go ahead, Mr. Schmidt.
No, I'm not asking questions just pertaining to your drug test today and your pre-trial release conditions. You understand that?
Yes.
Now, you met in my office with me, I guess this probably the beginning of November, is that correct?
Yes.
Now, in November, we went over your conditions of pre-trial release in detail, did we not? Yes. And I informed you of what you can and can't do, including no marijuana, correct? Yes. And you admitted to Mr. Waddell that you used marijuana in October, is that correct?
Yes, sir. It was like an edible, edible like form of marijuana, but it wasn't like, I didn't smoke any marijuana. It wasn't.
But prior to that, you'd used marijuana recently, is that correct?
Yes, sir.
And after our meeting and after my explanation to you of exactly what's required of you, have you used since then?
No, sir.
Mr. Woodward, any questions?
No question.
All right, any argument, Mr. Schmidt?
Judge, I mean, based on the testimony, I'd ask that the court not invoke Mr. Rate's bond for spelling, testing for compliance. I can tell you that, out of conversations, you know, there was some confusion and ultimately, hopefully there's no confusion now. But if subsequent tests show a reduction in the levels, and it would show that he's stopped using. So we'd ask that people hold on.
All right, Mr. Zarate, I'm gonna have to treat you like everyone else, so I can be consistent. I'm of course gonna find that you were on conditions of pretrial release that prevented you from using substances such as marijuana, that you violated terms and conditions of your community supervision. Of course, gonna find that your bail is insufficient at this time, and of course, gonna revoke your bail and take you into custody. Mr. Schmidt, I will entertain a motion to reinstate bail or reduce bail after sufficient time has passed.
Yes, sir. Thank you.
All right. We'll get his phone and wallet, anything that he wants to give to you. We'll make sure that you get it. You can bail him back out. Yeah, go ahead and have it. Go back in the hallway and they'll give you information. It's okay. It's okay. It's okay. If you're accusing, you have to do the proving. I don't have to answer your questions. That's about right. Present your evidence. Well, I'm hoping it does, so I'll get some workers' comp.
It was way early. Hold on. We haven't signed any of them.
You guys should sign it before that.
I don't like to release my signature to unknown individuals, like Richard Schmidt.
I was gonna say, Richard's not, I know, Richard's a no, I'm still not gonna say.
Known but untrusted.
Just put a little smiley face. So that.
Yeah, that's what we're saying.
Gotta have a look at this,
Hello Kitty.
Richard, that's not fair. She's pulling on
Lisa Frank unicorns, maybe.
it. Lisa Frank, that's that.
Judge, may we approach off the record before we do these two, please?
Brandon Sanchez, CR 22-251. Mr. Sanchez, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand, speak up loudly and clearly for me. Your name is Brandon Lee Sanchez, is that correct?
Yes, sir.
And this is CR 22-251. Mr. Sanchez, you are charged by information with a Class A misdemeanor offense of possession of a controlled substance in penalty group 1 less than 1 gram. I see that there's a plea agreement in your case wherein you would plead guilty to that charge. The state would be recommending that that you plead guilty to the lesser included offense of possession of a controlled substance, penalty group 1 less than 1 gram, for your punishment to be assessed under section 1244B of the Texas Penal Code, and that your sentence be assessed at 11 days confinement in the county jail, with you receiving 11 days credit for time already served, that you pay a $500 fine, $180 restitution, and the DA's office would be dismissing another possession case. In addition to those terms, you would also have to pay reimbursement fees of $535, court costs of $270. The range of punishment for a Class A misdemeanor is a maximum confinement up to 365 days and a fine not to exceed $4,000. Do you understand that range of punishment and the plea agreement in this case?
Yes, sir.
And Mr. Sanchez, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
Mr. Schmidt, is your client competent today?
I believe so, Jeff.
And you've explained to him his rights as it pertained to this case of his plea agreement? You believe that he understands his rights and the waivers he's making herein?
Yes.
All right, Mr. Sanchez, understanding the plea agreement and the range of punishment, you still wish to go forward?
Yes, sir.
All right, Mr. Sanchez, how do you plead to the Class A misdemeanor offense of possession of a controlled substance? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No, sir.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No.
Court will review the evidence. If you want to, you can just
Yeah, we're
open the blind, just open the blinds a little bit, and it won't be so.
Judge.
Yeah, the further away you put it, the harder it'll hit me.
It's gonna be a star, right?
Yeah. Let me get hit right by the star. Is there a lab report for this case?
There is.
And Judge, I believe what's Heisman, to approach out, right, there's
She did.
some reasons for.
She told me.
Okay, just in case. For that question.
Mr. Schmidt, can you maybe sign this waiver of Zoom? Mr. Schmidt, do you have any objections to the inclusion of the DPS lab report in evidence?
No, sir.
Court will include that with the state's evidence. Based on review of the evidence in this case, the court will find that there is sufficient evidence to convict Mr. Sanchez of this offense. Court will follow the plea agreement. Court hereby convicts Mr. Brandon Sanchez of possession of a controlled substance, penalty group 1, less than 1 gram. Assesses his punishment under Section 1244B of the Texas Penal Code. Class A misdemeanor with punishment assessed at 11 days confinement in the county jail. Court awards Mr. Sanchez 11 days credit for time served, orders him to pay a $500 fine, $180 restitution, $535 reimbursement fees, $270 court costs, and the court will dismiss under Section 1245 DA 2022-594. Mr. Sanchez, once you are through getting your finger printed and getting a copy of this, I want you to go upstairs. Do you plan on paying off everything you owe today?
No, sir, I was gonna get a payment and nothing makes.
Okay, so I want you to go ahead and go upstairs and talk with Ms. LaFrad about kind of what your plan is and get an appointment and do what you need to do, okay?
Yes, sir.
All right, come over here with Deputy Everett. He's gonna take your fingerprint. Dugan Toms, CR 22158. All right, Mr. Toms, if you'll raise your right hand, sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God? You can lower your hand. Your name is Dugan Lee Toms, is that correct? Mr. Toms, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney? You feel like you've had enough time to talk with him about your case and have all your legal questions answered? Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Schmidt, do you believe Mr. Thomas to be competent, and have you explained to him his rights?
Yes.
And you believe that he understands his rights and the waivers he's making herein?
Yes.
Mr. Toms, you are charged with manufacture or delivery of a controlled substance between 4 grams to 200 grams. That is a first-degree felony offense. If convicted and sentenced, that would have a range of punishment of not less than 5 years up to 99 years or life confinement in the Texas Department of Criminal Justice. I see here that there's a plea agreement in your case wherein you would plead guilty to that crime in exchange for the state's recommendation that your punishment be assessed today at 10 years confinement in prison, with that sentence being suspended and you being placed on probation or community supervision for 6 years. In addition, you would have to pay a $1,000 fine, court costs of $290, reimbursement fees of $535, and restitution of $180. Is that your understanding of the plea agreement? And that's what you're asking the court to approve? All right, then, Mr. Toms, I'm going to ask you, how do you plead to that offense? Are you pleading guilty to that offense because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence? State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Your Honor, I would just ask that you check the certificate on that as well, if we can get you the evidence, if it's not included, I did not check, but other than that, state the rest.
Anything further from the defense?
No,
Yeah, I don't see a lab report for this one either.
We would ask that this be added to the end of states.
Any objection to the lab report, Mr. Schmidt?
no,
All right, court will include the lab report in the state's evidence. Previously admitted. All right, court has reviewed the evidence. Court will follow the plea agreement in this case. Court finds that there is sufficient evidence to convict Mr. Dugan Lee Toms of this offense. Court hereby assesses punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspends that sentence today, places Mr. Toms on 6 years community supervision, orders him to pay $1,000 fine, $180 restitution, $290 court costs, and $535 reimbursement fees. Mr. Toms, you've been on probation before?
yes,
Okay, misdemeanor or felony? Felony. Did you successfully complete it? Okay, you didn't end up going to prison? Okay, so you understand what's at risk here. You understand if you don't comply with all of these conditions of community supervision that you signed today, you understand that the state could file a motion to revoke your community supervision and could ask this court to place you back in prison if they can prove to me that you violated any of these conditions. You understand that? And if you violate and they prove it to me, you understand that your sentence is already assessed today at 10 years in prison. You understand that? Okay. All right, Mr. Toms, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. Have you go over with Deputy Everett here to be fingerprinted, and then the probation officers will give you more information. Before we call Mr. Bustamante, did Bobby Evans, did you ever get any information on him?
sir, I did not, Judge, you know.
Yes.
No way about it.
Okay. You ready, Mr. Bustamante?
Yes.
Mr. Bustamante? This cause number CR 21-9, CR 21-281. Mr. Bustamante set for plea today. Go ahead, Mr. Schmidt.
Judge, we are set for plea today. However, I discussed with Mr. Bustamante in terms of the agreement. I could tell the courts under the circumstances, he's having some difficulty understanding the terms and conditions, and based on his expressions to me, I'm uncomfortable moving forward. However, we're not rejecting the state's offer. In addition, me and Mr. Monte have set an appointment in my office on December 20th at 1:30. He's bringing his VA medical paperwork with him to my office, and we're going to see if we can get the VA on the phone. I have contacted them on his behalf in the past, and it's moderately successful. So the goal is to get him into treatment immediately so that we can resolve this case and hopefully prevent future.
State is unopposed.
All right, court will reset. Mr. Bustamante, you want that February 7th date, Mr. Schmidt, or? Court recess, Mr. Bustamante, for plea on February 7th. And Mr. Schmidt, if the situation presents itself that you want to get set sooner, then just notify Ms. Tatum and we'll find you some time to get Mr. Bustamante in sooner if that needs to be the case.
That's absolutely.
Deputy Everett, will you call the name Bobby Lynn Evans, loud distinctly 3 times?
Bobby Evans. Bobby Evans. Bobby Evans. No response, Your Honor.
All right, Mr. Bobby Lynn Evans, CR 22-271 was set for arraignment today. Mr. Evans has failed to appear at 9 a.m. His name is called. He's not present at this time, which is approximately 11:30 a.m. Court has had his name called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nasi and alias casus. I believe that is all of the morning doc. Is that correct?
That's all I show you.
All right, court will stand in recess until 1:30. We'll resume with the jail document.
Go.